From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Two justices weigh in on the Supreme Court's legitimacy, or lack thereof, allegedly. But is there a real problem here, or is this merely a political campaign? Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnists Kim Strassel and Alicia Finley. Welcome and happy Friday to you both. After a drama-filled Supreme Court term this past year, including big cases on abortion and the EPA's power to fight climate change, two justices are now weighing in on the public debate. These comments that are floating in the ether from politicians or from commentators about the court's legitimacy. And let's start with Justice Elena Kagan speaking Wednesday at a forum at Northwestern University School of Law.
When courts become extensions of the political process, when people see them as extensions of the political process, when people see them as trying just to impose personal preferences on a society, irrespective of the law, that's when there's a problem, and that's when there ought to be a problem. So, what makes a court legitimate is that the court is acting like a court, is doing something that's recognizably law-like. And that's when a court will build up some reservoir of public confidence and goodwill.
So you heard Justice Kagan there, Kim, and it's a very tactful statement. She doesn't mention throughout her speech at all any of the cases that we're talking about here, particularly Dobbs, which overturned Roe v. Wade. And she's even speaking in some generality. She's talking about courts maintain legitimacy, not even the court, the Supreme Court. But am I wrong, Kim, to think that the obvious context here is the overturning of Roe v. Wade and the blowback to the Supreme Court's decision there?
Of course it is. And it's kind of a shame that she decided to go there because as the senior most Democratic appointee of the liberal wing of the court, now on the court, I think she probably thinks of herself as an institutionalist. And yet those comments very much will feed what we have seen is a Democratic and media project to tarnish the court's reputation and its impartiality. And I think one of the things that just is stunning when you disassemble this comment as well, too, is that it gets everything completely backward in that the court's goal with Roe v. Wade and then Dobbs and overturning it was to be political. It certainly isn't working out very well at the moment for Republicans, given that this has thrust the issue back into the legislative process at the state level, galvanized Democratic voters, and put a lot of Republican candidates in a tough position. And so it's a kind of a bizarre statement to make because it doesn't reflect political reality. But again, the bigger point is that let's not go there in that you've got Democrats, the president, Democratic leaders all trying to undermine the court. And we don't need justices using not very veiled nuance to make the same case.
The other thing that struck me as really interesting about these comments, Alicia, is that you can close your eyes and sort of imagine that the speaker is somebody like the late Justice Antonin Scalia, and it's a Federalist Society event that you're listening to. I'll read a couple more quotes from Justice Kagan. When the court gets involved in things it doesn't have to, especially if those things are very contested in a society, it just looks like it's spoiling for trouble. It looks like it just wants to decide those matters, unquote. And I bet a lot of conservatives, they hear something like that and they're nodding their heads and saying, exactly, that's exactly right. That was the exact problem with the Roe v. Wade decision in the first place. Then Justice Kagan was asked about this too. She was asked about stare decisis, the judicial penchant for deferring to precedent. And she was asked what can overcome stare decisis? What is a situation where judges may decide that a previous court got something wrong and they need to overturn it? And she cited a couple of examples, but here's one of them. When you've discovered that the doctrine that the court has created is entirely unworkable is usually the expression. She went on to say that a situation like that might be when a complete mess has been created. And Alicia, again, that struck me because I read the Dobbs opinion overturning Roe v. Wade, and Justice Samuel Alito, the author of that opinion, has a long section where he talks about the difficulty of asking judges to decide when some sort of abortion restriction is a quote unquote undue burden on abortion rights and when it isn't. And so I don't think that Justice Alito would disagree with Justice Kagan's analysis on the stare decisis point, he just thinks that he's already done that. Go read the opinion would be, I think, what he would say.
Right. So I think one of the problems was this undue burden standard was kind of concocted out of whole cloth. There was really no basis in the Constitution for it. And so judges, as you note, have been applying it differentially, or in some cases, judges have ruled that parent notification laws could present an undue burden for teenagers. In other cases, and actually in most cases, federal judges have been striking down, or before Dobbs' decision, had been striking down any kind of restrictions or state laws that attempted to impose any what they called an undue burden on abortion rights. But again, these could vary to the extent that they could be parent notification laws, requirement that a woman, go get counseling beforehand. And to your point about workability, there is no definition of undue burden in either the Casey decision, which kind of spooled that out. And so there presents a problem when you have different judges interpreting this precedent differently. So eventually it was going to have to be struck down by the high court, because these cases were going to continue to percolate in the district courts and the appellate courts, with each judge or each circuit reaching its own conclusion, and you just have a hodgepodge of decisions. And so I think the court in this case wasn't waiting and it wasn't spoiling for a fight. It was going to have to decide this question eventually.
And one last thought on Kagan's remarks here. I'll go back to a piece of what we played earlier. She said what makes a court legitimate is that the court is acting like a court. It's doing something that is recognizably law-like. And Kim, why that sticks out to me so much, again, is I'm not a lawyer, but I've read plenty of briefs and opinions, and I read the Alito opinion, and it certainly looks like law to me. And to your point, Kim, about the rhetoric, it is really striking, I think, that the clear implication of what Kagan is saying here, and again, I know she's talking about a court and the courts, and she's being a little tactful in that regard, but the clear implication is that the conservatives on the court, her colleagues, are doing something that is not law-like. And I think it's really notable to have a Supreme Court justice out in public saying that.
Not only is Alito's opinion definitely law-like, all 87 pages of it, but the important point here to make is the contrast with Roe v. Wade, which was not law-like at all. And this was always the problem. It was a political decision. It was actually invented, all of these rights, and then follow on the Planned Parenthood v. Casey decision, which created this undue burden standard. All of it created out of whole cloth. The original Roe decision by Harry Blackmun, who was actually a GOP appointee. It was actually a Democratic appointee, Byron White, who was in dissent, and in fact, who Alito goes to in his own opinion in talking about this. And this is the point, is when are you justified in overruling a terrible precedent? Well, as Justice Kagan says, when there is a mess, and we have had a mess ever since the Roe decision came out, and then Casey since it. So this was the court cleaning up its record in a very law-like fashion. And she knows that because, by the way, no honest judge, no academic on the left even, tries to defend Roe on the legal merits, and note that she didn't do that here either. Even in their dissent, the liberals on the court mostly referred to precedent and not really to the legal questions involved here. So I agree with you, therefore, on so many levels, unfortunate that she's going there, especially because if you look at the campaign by the left right now to delegitimize the court, it's certainly having an effect, particularly among Democratic voters for whom belief in the court is down profoundly, according to some recent polls, the Gallup poll in particular.
But we've been looking backward, and Alicia, what do you think about looking forward? I mean, is part of what Justice Kagan is doing here is offering a shot across the bow for the Supreme Court terms to come, and particularly some of the big cases that the court has already taken. There's one on gerrymandering and redistricting out of North Carolina. There's one on racial preferences in the university admissions policies at Harvard and the University of North Carolina. And I mean, Alicia, do you think part of the thought here, the strategy, is to provide a little bit of backing to the people in the public, the commentariat, who are saying that these are illegitimate decisions by an illegitimate court, and offering a bit of a warning to those conservative justices about the way they might rule in future cases?
I think that's right. I think this is particularly, of course, targeted at the chief who is likely to be the swing vote, or chief and Justice Brett Kavanaugh, who are likely to be the swing vote in the cases that you mentioned. The voting rights case, which concerns the standard in terms of redistricting or other voting rights laws, to the extent that state laws impose a disproportionate burden on minorities. And this has been in the news a lot. The liberals have made much ado about any state laws that impose not only voter ID requirements, but also redistricting maps, to your point, that there's this argument on the left that anything that reduces a majority-minority district violates the Voting Rights Act. And this is a very contentious debate and will be heard this fall. The other one you mentioned, the UNC Harvard on affirmative constitutionality of racial preferences and college admissions. This, again, very hotly debated, though I think actually the public opinion on this is very resoundingly against affirmative action. We've seen that in state referendums, most recently in California, where voters overwhelmingly upheld their state constitutional amendment that banned racial preferences in college admissions. In some ways, I don't think the public is necessarily on Kagan's side. I think she's trying to your point, send a shot across the bow to make the Just Chief and Justice Brett Kavanaugh and perhaps Amy Coney Barrett a little more weary of overturning the precedents, Grutter in the case of the affirmative action, and the Gingles precedent, which I think there's a lot of appetite to also overturn in the case of the Voting Rights Act case.